We're on the record in People versus Micah Burrows, case number 234833. Mr. Burrows present.
He's not, Your Honor. Or if he is, if he's in Zoom, I don't know. I attempted to contact him. His last known number. We'll contact him.
Okay. I don't see him on Zoom. You know when the last time you were able to meet with him?
Yeah, it was shortly before his release from incarceration. He was homeless, so.
Okay, it looks like he failed to appear back in September as well. Mr. Ziegler, do people take any position on this?
Your Honor, given his prior failure to appear, the people would request a bench warrant matter.
All right, I think that would be appropriate. So if you could prepare that, the court will sign it and we'll proceed with Mr. Burrows' case once he's arrested and brought before the court. People versus Wagon Shoes case.
We're ready, Your Honor.
Oh.
Thomas Seeger appearing with an behalf of Mr. Williams.
This is file 234842 and 4843. Can you tell me where we're at in this case?
Your Honor, it's my understanding that Mr. Wagon Shoes is going to tender a plea in 234842 to an added count of possession of narcotics, which would be treated under 7411. In exchange, the balance of that file will be dismissed. Additionally, Your Honor, it's my understanding that you will plead to 234843 FH, which will be treated under HIDA, and they would plead as charged in that file.
Okay, so in 4842, an added count 6 of the 4-year possession of narcotics.
Correct, Your Honor.
You have the fact code for that, Mr.
333-7403-2A5.
Okay, and which substance are we going to take the factual basis to as to that count?
Your Honor, he would just state that he was growing mushrooms, psilocybin. Your Honor, the only question that I have, and this is for record keeping, the information, I don't currently have it, and one of the counts were not found, he was not found over on, so I just want to make sure that everything matches, just for record keeping, Your Honor.
So I've got a 5-count information. Not sure what
Count 1 originally, which was dealing with peyote. I don't know if that was reflected in yours, Your Honor, but that count was not found over.
Okay. All right, so this would actually be then an added count 5.
Yes, Your Honor.
Okay. All right. Other than what we discussed, Mr. Ziegler, are the rest of the terms of the plea accurate from your standpoint?
Yes, sir.
Okay. Mr. Wagenschutz, have you had a chance to talk to Mr. Seeger about this plea agreement?
Yes.
Is that how you want to proceed today?
Yes.
Okay, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do, Your Honor.
All right. Are you currently on any kind of probation or parole?
No.
All right. And you understand that by pleading guilty to possession of a narcotic, that the maximum possible penalty you could face would be up to 4 years?
Yes, I do, Your Honor.
And that by pleading guilty to malicious destruction of property, that's also carries with it a maximum possible penalty of up to 4 years. Do you understand that?
I do.
With those penalties in mind, what is your plea to each of those charges today?
Guilty.
Right now, you have, excuse me, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights.
I do, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to do that, you'd have to ask the Court of Appeals to hear your case. They could say no, and that would be the end of any appeal. Do you have any questions about that?
I don't believe I do. Your Honor.
Okay. Has anybody threatened you with anything to get you to plead guilty? Has anyone promised you anything other than what we've said here in court today?
No.
Is it your own free choice to plead guilty?
Yes, it is, Your Honor.
Are you pleading guilty because you are in fact guilty of each of these crimes?
Yes, Your Honor.
Okay. So the older file, this is the possession charge. It looks like that was back in March 3rd of 2023. Is that correct?
I believe so.
Okay,
Sorry, I'm bad with dates.
that's all right. Do you have any reason to believe that that would not be the right date or time frame?
I wouldn't be able to tell you honestly.
Okay.
Like I said, I don't even know my own birthday half the time.
Okay. You don't have any reason to think it wasn't in March? Okay. At that time, were you present here in Kalkaska County?
Yes, Your Honor.
While you were present here in Kalkaska County, did you have possession of some mushrooms or psilocybin?
Yes, Your Honor.
Did you know that that's what that substance was?
Yes.
Did you have any legal right to be in possession of it at that time?
No, Your Honor.
And then the second charge, malicious destruction of property, this indicates that happened on May 27th of 2023. Does that sound right?
Yes, Your Honor.
At that time, were you also here in Kalkaska County?
I was.
All right, and did you come into contact with the Kalkaska County Sheriff's deputies on that day?
I was in jail on that day and I was making a call to my mother and the conversation wasn't as sweet as normally our conversations were, and I had a breaking point. I slammed the phone down and it was broke.
Okay, thank you. Mr. Ziegler, as to both counts, are you satisfied with the factual basis?
Yes, Your Honor.
Mr. Seeger?
Yes, sir.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Seeger?
No, Your
And Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Seeger?
Yes, sir.
Mr. Wagenschutz, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to both. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with Mr. Seeger prior to that date so that you're ready to go forward, okay?
Yes, Your Honor.
Today, before you leave the courthouse, you need to go across to the building right next door here and check in with the probation department. They're going to give you a packet to fill out, okay?
Right.
Mr. Seeger, anything further today?
No, Your
Mr. Ziegler?
No, Your Honor.
Honor. Your Honor, he just wants to see if his mailing address is updated because I've forwarded dates for him, but he just wanted to make sure that it's correct with the court.
Okay, yeah, can you give us your current address?
It's P.O. Box 1417 at the Kalkaska Post Office.
Okay, all right, thank you.
Thank you.
We get the Wexford jail acting in here. That's Mr. Truce, I think.
Yes, Your Honor. Ms. Leffingwell is also here.
Okay, let's take Ms. Leffingwell's matter real quick then. People versus Leffingwell, case number 234836. Could have council put your responses on.
Ryan Ziegler.
Tom Seeger, I'm working on behalf of Ms. Lovingwell.
Thank you. Mr. Seeger, how did we want to proceed in this case?
Your Honor, it's my understanding that Ms. Lovingwell is going to plead to an added count 2 of attempted resisting restraint. Additionally, Your Honor, it's my understanding that the people have no objection to full cost.
Mr. Ziegler?
Fair statement of the offer, Your Honor.
Ms. Leffingwell, have you had a chance to speak with Mr. Seeger about this plea?
Yes.
I just needed that. I know your voice is
Yeah.
a little hoarse. Okay.
Yeah.
We're recording, so it has to come through.
Okay.
All right, and is that how you want to proceed this morning?
Yes.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Ms. Leffingwell, are you currently on any kind of probation or parole?
No.
You understand that by pleading guilty to attempted resisting or obstructing, that the maximum penalty you could face would be up to 1 year?
Yes.
With that in mind, what is your plea to that charge today?
Guilty. Or to attempted resisting arrest.
Correct.
Yes.
Okay. Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify yourself if you wanted. Do you understand that you have all those rights?
Yes.
You understand that you're giving up and waiving all of those rights by pleading guilty?
Yes.
Has anybody threatened you with anything to get you to plead guilty?
No.
Has anybody promised you anything other than what we've said here in court today?
No.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are guilty?
Yes.
Okay, so this happened on March 5th of 2023, is that the correct date?
Yes.
And on that date, did you encounter a deputy from Kalkaska County?
Yes.
And did that happen here in Kalkaska?
Yes.
Was that deputy wearing their uniform?
Yes.
Did you know that that person was there performing duties as a law enforcement officer?
Yes.
Did you what happened or what was going on that resulted in this attempt?
Your Honor, may I assist her with her objection of business? So, Ms. Lovingwell, you were approached by Officer Hall, correct?
Mhm.
Is that a yes?
Yes.
All right, and he asked you to get out of the car, correct?
Yes.
And you refused to get out of the car.
Yes.
And during the course of it, you were aware, or he made you aware that he was investigating a public disturbance of some sort, correct?
Yeah.
All right, at which point you refused to get out of the car, even though he asked you to get out of the car.
I don't remember maybe out of the car, just rolled down, but that's okay.
All right, well, he gave you a lawful command to exit the vehicle, right?
To roll the window down.
All right, and you refused to get out of the car, right?
Yes.
No further questions, right?
Mr. Ziegler.
I'm satisfied.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Seeger.
No, sir.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Seeger.
Yes, sir.
Ms. Leffingwell, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this attempted RNO. The court will accept your plea. Is there any objection to proceeding with sentencing right now, Mr. Ziegler?
No, Your Honor.
Mr. Seeger?
No, yeah.
Ms. Leffingwell, you do have the right to have a pre-sentence report prepared and have this set for hearing at a separate date. The lawyers are indicating that they would like to proceed with sentencing today. You understand you have that right.
Yes.
Do you have any objection to going forward with sentencing today? Mr. Ziegler, anything that on behalf of the people for allocution?
Your Honor, this was a circumstance where Ms. Leffingwell was outside of a building. Police were called. The first officer on scene, Deputy Hall, asked her several times to roll the window down or to step out of the vehicle. She refused to comply with those commands. Another officer, Deputy Lester, arrived on scene, and Deputy Lester was able to talk Ms. Leffenwell out of the vehicle. They had some concerns about whether she was under the influence of a controlled substance, whether she was suicidal. They ultimately took her into custody for R&O. But this was not a circumstance where she was fighting with the police. This was not a circumstance where anyone was put in any real physical danger. So for those reasons, Your Honor, the people have no objection to fines and costs given the nature of the plea.
Thank you, Mr. Seeger.
Likewise, Your Honor, I would just ask the court to limit it to full cost and fines. Clearly, the conviction has its own problem that's attached to it. I think that Ms. Leffenwell was experiencing some mental health crises. She was not thinking rationally. When I did subsequently have an opportunity to discuss it with her, I think she later realized that she could have acted differently. Or maybe her state of mind at the time, she probably would have acted a little bit differently. But be that as it may, Your Honor, she's just asking the court to limit it to full cost of fines. And she did waive her competency and criminal responsibility.
Thank you. Ms. Leffingwell, anything that you wanted to say?
I just want to say I was at a church that where my daughter's funeral was, and I was crying and real upset. That's it. So I was just scared.
Having heard, a little bit more about what happened in this case based on what you and the lawyers have said.
Yeah.
It sounds to me, there are some offenses that are more appropriately dealt with through monetary punishment, both jail type of thing, and I think this is appropriate for that. And so I agree with counsel that fines and costs is an adequate way to address this. So the court is going to impose a $68 state cost for crime victims assessment of $130, court cost of $325, and attorney fees of $350. You do have the ability to seek an appeal of this sentence. If you wanted to do that, you would need to file for that within the next 21 days. If you have questions about that, Mr. Seeger, I'm sure would be able to answer those for you. Otherwise, before you leave the court today, if you could go across the way to the clerk's office, arrangements for you to make those payments. Mr. Ziegler, anything further that we need to address on this file today?
No, Your Honor.
Mr. Seeger.
No, sir.
Thank you, Ms. Leffingwell. That's all for today. Okay, Mr. Cruz there in Wexford County, I just need you to unmute on your end. There you go. Can you hear me okay?
Yes, sir. Yes, sir.
All right, and are you Matthew Troost?
Yes, sir. Yes, sir.
Okay, we're on the record in People versus Matthew Troost, case number 234848. The record should reflect Mr. Troost is appearing today by video from Wexford County. If I could have counsel put your appearances on.
Ryan Ziegler, on behalf of the people, Your Honor.
Thomas Seeger, planning with the Mr. Cruz.
Mr. Seeger, how did we want to proceed in this file today?
Your Honor, it's my understanding that Mr. Chus is going to plead guilty to pleading and alluding in the 4th degree, which is count 1, to your felony, in exchange count 2 and count 3 will be dismissed.
Mr. Ziegler, is that a correct statement of the plea offer?
It is, Your Honor.
Mr. Troost, were you able to hear that?
Yes, sir.
Yes, sir.
And have you had a chance to talk to Mr. Seeger about this plea?
Yes, sir.
Yes, sir.
Is that how you want to proceed today?
Yes, sir.
Yes, sir.
Can you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Yes, sir.
Thank you. You can lower your hand. Mr. Troost, are you currently on any kind of probation or parole?
No, Your Honor.
All right, and you understand that the maximum possible penalty that you could face for fleeing and eluding 4th degree is up to 2 years and or a $500 fine and suspension of your driver's license for 1 year.
Yes, Your Honor.
With that in mind, what is your plea to that charge today?
Guilty, Your Honor.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, Your Honor.
You understand that you're giving up and waiving all of those rights by pleading guilty today.
Yes, Your Honor.
Has anybody threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we said here on the record today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty because you are guilty?
Yes, Your Honor.
The information I have indicates this happened on June 30th of this year. Is that the correct date?
Yes, Your Honor.
And on that day, were you operating a motor vehicle here in Kalkaska County?
Yes, Your Honor.
All right, and at some point when you're operating that vehicle, did you come into contact with a police officer?
Yes, Your Honor.
And was that officer driving a marked police vehicle?
Yes, Your Honor.
And did that police officer direct you in some way, either by lights or sirens or otherwise, for you to pull your car over?
Yes, Your Honor.
And did you fail to do that?
Yes, Your Honor.
Okay. Mr. Ziegler, any further questions?
No, Your Honor.
Mr. Seeger?
No, sir.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Seeger?
No, Your Honor.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, sir.
Mr. Truce, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing, and you'll be notified of the date and time of that hearing. Mr. Ziegler, anything further we need to address today?
No, Your Honor.
Mr. Seeger?
No, Your Honor.
All right, thank you, Mr. Truce. That's all for this hearing today. The court's going to disconnect at this time. Okay. And is Ms. Webster, is she?
She's right here.
Oh, are we ready to go forward?
Yes, Your Honor.
Okay. Okay, Ms. Webster, you can go right up to the podium there, please.
Yes, sir.
Thank you. We're on the record in People versus Webster. This is case number 234801 and 4804. The record should reflect Ms. Webster's present here in the courtroom today. This is the date and time set for a sentencing hearing. If I could have counsel put your hearing.
Your Honor.
Thomas Seeger, appearing with and on behalf of Ms. Webster.
Thank you. Ms. Webster, have you had a chance to go through the pre-sentence report and talk to Mr. Seeger about that?
Yes, sir.
Okay. Mr. Seeger, are there any additions, deletions, or corrections today?
No, Your Honor.
Are there any challenges to the guidelines as scored?
No, sir.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the guidelines?
No, Your Honor.
Do you have any victims that wish to address the court today?
No, Your Honor.
Anything on behalf of the people for allocation?
Your Honor, largely I would support the recommendations contained in the PSI. This is Ms. Webster's first felony. I think the recommendation for probation is an appropriate one. I think she deserves a chance to demonstrate to the court that she complied with the terms of probation. She's already served 57 days. I support all those recommendations. I think they're appropriate. I'd ask the court to adopt.
Thank you. Mr. Seeger?
Your Honor, likewise, I would just ask the court to follow the recommendations. I think that Ms. Webster, when I initially had met her, was really struggling with her addiction. She was struggling to communicate. A lot of things that she was saying were not making a whole lot of sense, but over the course of time, I think that the period of incarceration has allowed her to maybe contemplate how using drugs affects her. And I do understand why maybe she got involved with it. That she has a substance abuse problem. To her credit, Your Honor, she's set up drug treatments for which I think that there was a better available for today. We should be able to get into that situation immediately. She did indicate to me that she would follow through with her probation, if given the opportunity to do so. I agree with Mr. Zaylor, she does not have a long, extensive criminal history. She does have some pending matters that she's going to have to resolve, but that's not something that we can control. But in any event, she is hopeful that she'll be able to put all this behind her and move forward. But again, Your Honor, I guess I can only say that she has made a good effort to try and curb some of the problems that she has, and she definitely has more insight now than she did when we originally started talking.
All right, thank you. Ms. Webster, anything you wanted to say?
Yes, sir. Your Honor, today I'm here before you for sentencing. I take full responsibility for actions and charges I have been stating before you today. I'm praying that you find it in your heart to send me to treatment and release me today. NMRE approved me for intensive inpatient rehab at Phoenix Hall in Traverse City. I ran for age this last week. They have a bed open for me today. Jail honestly made me clean, but I still need the skills to be sober and stay sober. In jail, we're clean because we have to be. Outside, we're sober because we want to be. I have 4 children out there that need me. In a few months of having used, I've lost everything that meant so much to me. The person that committed these crimes is not the real me. The person standing in front of me today is embarrassed for what I've done, and I'm ready to go to treatment and come home and fight for my children. Sober. While in rehab, I plan to set up appointments with neurologists to get my seizures under control. I believe everything happens for a reason, and this has been a huge eye-opener for me. Even would like to be placed on probation. A little extra tough love. I'm just praying to release me today. I want to better my life. I can't do it from jail with other addicts just bragging about wanting to get high. I want to be sober and will be sober. Thanks for your honor for taking the time to allow me to read this. Sincerely, a recovering addict.
I did read through the report, so I'm familiar with the facts of these cases that bring you here today. There's also a lot of information in that report about your background and circumstances. So I take all of that into consideration, along with what the lawyers had to say. And of course, I've listened very carefully to your letter that you read as well. Looking at all of the circumstances as a whole, I think, you've served 57 days, as the prosecutor indicated. The guidelines are 0 to 9 months. So I think whatever benefit we can get in terms of jail time we've gotten now. So I think it's time to move on to more of the rehabilitation phase of this, which includes the probation and your treatment. So I'm not going to order any additional jail time. I am going to make as the conditions of your probation that you go into that residential treatment program if you have a bed available today.
It's open at what? I could be there at 1 o'clock.
Okay, great, because I think that's really where you need to go from here.
Thank you.
In order to do those things that you want to do. So I'm going to file the recommendation with the exception that the court's going to place you on probation for 18 months instead of 12 months. But other than that, the court is going to adopt all the terms and conditions listed in the report, including that you participate in and complete residential substance abuse treatment. The court is going to order that you serve 57 days with credit for 57 days served, and again, probation of 18 months. A crime victim's assessment of $130, court costs of $325, attorney fees of $350, state cost of $68, and a DNA testing fee of $60, along with, while you're on probation, a supervision fee of $30 per month. And that is all with regard to file 234801. With regard to 234804, a crime victim's assessment of $75 and a $53 state cost. You do have the ability to seek an appeal of these sentences. You can provide this with for appellate rights. Ms. Webster, these papers are going to explain to you what your appellate rights are, as well as how to request a court-appointed lawyer. Ms. Wagner, are you going to be the supervising agent?
Yes, Your Honor.
So if she goes into treatment today, how do you want to make contact with her in the jail here before she's released, or how do you want to handle that?
I can make contact with her here in treatment. She has already signed the necessary release information, so I can contact her at ATS.
Okay, all right, so Ms. Wagner is going to contact you in your treatment program, so just follow up with that, okay?
Okay.
Mr. Ziegler, anything further we need to address on this file? Mr. Seeger?
No, sir.
All right, good luck to you going forward, Ms. Webster.
Thank you, I appreciate you.
Your Honor, I think the close is my bag. Get about this. I'm making an error somewhere.
Okay, thank you. Our next hearing set for 10 o'clock, so we'll be in recess until that time. Okay, Mr. Travis, are you already in Ms. Brister's matter?
Yes, Your Honor, Mrs. Brister is in the courtroom, and we're ready to proceed.
Versus Brandy Brister, case number 224661. If I could have counsel put your appearances on.
Kyle Travis on behalf of Mrs. Brister.
So this is set for a hearing today. Ms. Brister's delay of sentence. Ms. Brister, did you receive a copy of the updated report?
Yes, sir, I did.
Okay. And Mr. Travis, are there any factual corrections that need to be made to the updated report?
I don't believe so.
Mr. Ziegler, do you have any corrections?
Okay.
Anything on behalf of the people today?
Your Honor, I would support the recommendations contained in the updated report. It sounds to me in reviewing that report, Ms. Brister has relatively complied with all the terms of the payment of the fines and costs. It seems to me that there's no reason she wouldn't have been able to make better efforts to pay those fines and costs. For those reasons, Your Honor, I think that the recommendation of just not giving her the benefit of the delay sentencing her to the charge and preserving those full cost of fines for collection. I think that's an appropriate penalty, given the circumstances here. I don't think any warranted. Just losing the benefit of the delay is already a significant blow to the defendant. So I think that's an appropriate sanction, Your Honor, and ask the court to adopt those recommendations.
Thank you. Mr. Travis?
Thank you, Your Honor. Largely, as much as we'd like to ask the court to grant the delay, we understand that the terms haven't been fulfilled. I think in speaking with Mrs. Brister and reading the report, all in all, as much as this hasn't been successful, everything hasn't been done, Ms. Brister's made a lot of progress. I think there's a reason that the recommendation is to do as it is. Over the course of time, it became, I think, somewhat more clear that Ms. Brister did have an issue with methamphetamine. She was kind of in denial of that at the beginning of this case. Her and her husband do have something of a dysfunctional relationship. Whether they fix that and stay together or not, remains to be seen. She had been, I guess, traditionally a homemaker for a long time. So I understand very much the feeling that, hey, she could have gotten work, but other family things kind of got in the way of that. And unfortunately, at certain points, substance abuse got in the way of that, but she's doing quite well now. I think she's
146 days.
146 days without any legal narcotics use, which in speaking with her, it had been a couple of years before that had happened. So we do have some actual solid success here. It's just not complete success, Your Honor. Thank you.
All right, thank you. Ms. Brister, anything you wanted to say?
I would just like to say, I apologize for taking the court's time, and I apologize for taking so long to get my butt in gear. I was in a domestic relationship we've been together almost 18 years, and the last 5.5 was really bad. And it took him going to jail and me realizing that, my life needs to take a turn for the better, and I need to get my butt in gear and get this completed, and I was trying, and I just wasn't successful at it. And I can be successful at it and can show you and prove it, not just to the courts, but to myself. Because for myself and my children, it's worth my sobriety and to have this completed.
All right. So I did read through the report, familiar with how things have gone over the past year. I agree with counsel. I mean, there was a degree of compliance, but when we allow for a delay of sentence like this, then there really isn't room for anything other than full compliance. And there were obviously some issues during that period of time. So hopefully you can build on the positive things that you were able to do over the past year. Based on the things that didn't happen, the court is going to follow the recommendation, however. And so the court is going to order that any of the outstanding fines and costs remain preserved. You did serve 5 days, so you get 5 days worth of credit for 5 days served. The court is going to order that the original conviction stand. Is there anything else we need to address, Mr. Ziegler,
I don't believe so, Your Honor.
Mr. Travis?
I don't believe so.
Ms. Brister, good luck to you going forward.
Thank you very much. I appreciate it, sir.
People versus Domke, case number 224754.
Aaron Kyle Travis on behalf of Mr. Domke.
Ryan Ziegler on behalf of people, Your Honor.
I don't see Mr. Domke present in the court today. Have you had any contact with him, Mr. Travis?
I have been unable to reach him ahead of this date and speak with him about it.
Mr. Ziegler, do the people have anything to add to that?
Your Honor, the court will recall that the trial in this case, which was set sometime in mid-September, was adjourned at the people's request due to some issues getting a hold of the victim and the victim's family. I did send a deputy over there over the weekend who had contact with the victim and the victim's family. They have expressed the desire that they do not wish to proceed. I'm trying to make efforts to get a hold of them myself so I can have a conversation with them about what that would mean. I had my crime victim advocate call them yesterday and this morning. I've not heard back. I would ask the court to issue a show cause for Mr. Domke, given that we were going to ask for an adjournment anyway. And hopefully I'll be able to resolve getting a hold of the victim and figuring out where this case is going to go in February.
All right, so given those circumstances, given that there was an adjournment of the trial date by ex parte motion, it doesn't appear, just from my review here at the file, that Mr. Domke's failed to appear for any prior hearings. I think all of that taken together, the court will set it for a show cause status conference. And we'll go from there. Mr. Travis, anything further we need to address in this file today?
I don't believe so, Your Honor.
No, Your Honor.
Your Honor, Mr. Armstrong's in the courtroom. If I could have just a moment to converse with him.
Yes. All right, Mr. Travis, are you ready to go?
I'm sorry, just a moment.
Run record in People versus Armstrong, case number 234838.
Try and say that, yeah.
Mr. Armstrong, you can remain standing at the podium there, please. Thank you. Mr. Travis, how did you want to proceed with this case?
Your Honor, it is my understanding that the prosecutor would offer a plea to count 2 attempted breaking and entering a building with intent, and that would be under the Homes Youthful Trainee Act, and that Mr. Armstrong would like to accept that plea offer.
Mr. Ziegler, is that a correct statement we offer?
It is, Your Honor.
Mr. Armstrong, you've had a chance to speak with your attorney about this? Have you had a chance to talk to your lawyer about this plea agreement?
Yes, Your Honor.
Okay.
But I really think I need more time to talk. I really don't know, Your Honor.
I'm sorry, I can't
I
hear you.
really think I need a second more to talk to him or think, Your Honor.
Okay. I can give you a couple more minutes here. You want to do that?
Possible. Okay, thank you.
All right. We'll come back. Mr. Travis, we'll come back on the record at 10:30, okay?
Thank you.
All right, we're back on the record in People versus Armstrong. Mr. Travis, how do we want to proceed today?
Your Honor, it's my understanding that Mr. Armstrong would like to accept the prosecutor's plea offer to count 2 with Home Youthful Trainee Act. If maybe I could ask him some questions for the plea.
For the factual basis?
Yes.
Okay. All right, Mr. Armstrong, is that how you want to proceed today?
Yes, Your Honor.
All right, can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, Your Honor.
Thank you. Mr. Armstrong, you can lower your hand. Are you currently on any kind of probation or parole?
No, Your Honor.
All right, and then you understand that this count 2, which is attempted breaking and entering, that carries with it a maximum possible penalty of up to 5 years. Do you understand that?
Yes, Your Honor.
With that in mind, what is your plea to that charge today?
Guilty.
So right now you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, Your Honor.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you'd have to ask the Court of Appeals to hear your case. They could say no, and that would be the end of any appeal. You understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we've said here in court today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty because you are guilty?
Yes, Your Honor.
All right, Mr. Travis.
Mr. Armstrong, back in mid-February of this year, were you in Kalkaska County?
Yes, sir.
Did you unsuccessfully try to open the door of a local business?
Yes, sir.
And was that to try and either steal something or money or some such thing?
Yes, sir.
And you were unsuccessful in getting into that door though?
Yes, sir.
Mr. Ziegler, any additional questions?
I'm satisfied with the factual basis, Your Honor.
Thank you. Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Travis.
No, Your Honor.
Mr. Ziegler, are the people satisfied that the court has complied with statute in the taking of this plea?
Yes, Your Honor.
Mr. Travis.
Yes, Your Honor.
Mr. Armstrong, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We're going to set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with your lawyer, Mr. Travis, prior to that hearing, okay? Before you leave the courthouse today, the building right next door here, you need to go to the probation office in there. You're going to check in. They're going to give you a packet to fill out, okay? Mr. Ziegler, anything further on this case?
No, Your Honor.
Mr. Travis.
Actually, we could check his address. You indicated you didn't get the notice and they had just recently moved.
All right, can you give us a current address, Mr. Armstrong?
1612 East Stockbridge Ave.
And what's the city?
Kalamazoo, Michigan,
You know the zip code?
49001.
I'm sorry, what was the city again?
Kalamazoo.
Oh, Kalamazoo. Thank you.
And Your Honor, I know we both, prosecutor and I had mentioned it, but Mr. Armstrong wanted to clarify that the offer was with HIDA.
That's my understanding.
That's correct, Your Honor.
Yes. And I just, we all said it, but I think you asked.
Sure, understood. Okay, that's all for today. Thank you.
Thank you, Your Honor.
versus Andrea Solis.
Here in the courtroom.
Case number 234844.
Brian Ziegler on behalf of people, Your Honor.
Kyle Travis on behalf of Mrs. Solis.
Mr. Travis, how do we want to proceed in this case today?
Your Honor, it's my understanding that the prosecutor would offer a possession of narcotics under 7411, and that Mrs. Solis would like to accept that offer.
That the 4-year possession.
That is my understanding.
That's correct, Your Honor. And as the factual basis to the cocaine as a substance.
Yes, Your Honor, the allegation is of the delivery part was that her and her friend may have been trying to make crack.
Mr. Ziegler, do you have the PAC code for that?
333.74032A5.
So this would be added count 2 then?
That's correct, Your Honor.
Ms. Solis, have you had a chance to talk to Mr. Travis about this plea?
Yes.
Okay, and is that how you want to proceed today? Could you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Ms. Solis, are you currently on any probation or parole?
I don't think so. Maybe.
So I believe she, and that may be a bit of a question. So, Your Honor, she had I think 2 district court files. She was on probation there. At the waiver for this and a sentencing for a probation violation, Judge Boudet, I believe sentenced her to 93 days, but authorized her to go to rehab. So she successfully completed that rehab. So I believe she is done with the probation, but she technically may still be on, but I'm pretty sure she's completed that.
Okay, but either way, Judge Boudet's already dealt with any kind of violation arising out of this.
Correct, Your Honor. And actually, Mr. Ziegler reminded me, there was also a misdemeanor matter that Ms. Solis would be responsible for restitution, but that would also be
I
dismissed.
have that. Oh, I have the money to pay that.
Well, we'll have to go through the prosecutor's office, but yes, that's good. That's good.
Okay, so that file will be dismissed upon payment of restitution.
Correct.
Okay. All right. And Ms. Solis, you understand that by pleading guilty to this charge of possession of cocaine, that the maximum penalty you could face would be up to 4 years. I think I'm going to need you to speak up.
Yes, Your Honor.
Thank you.
Yes, Your Honor.
With that in mind, what is your plea to that charge today?
I plead guilty.
Okay. So you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you if you're at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand that you have all those rights. You understand that you're giving up and waiving all of those rights by pleading guilty today.
I do, Your Honor.
Also, you don't have an automatic right to appeal that the plea that you're making here today. If you wanted to try to do that, you'd have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
I do, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we've said here in court today?
No.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are guilty?
Yes.
This happened on July 27th of this year. Is that the correct date?
Correct.
Okay. On that day, were you here in Kalkaska County?
I was.
And while you were here in Kalkaska County, did you have possession of some cocaine?
Correct. Yes.
Did you know that that's what that was?
Yes.
Did you have any legal right to have it at that time?
I did not. No.
Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Travis?
Yes, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Travis?
No, Your Honor.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court will undertake this?
Yes, Your Honor.
Mr. Travis?
Yes, Your Honor.
Ms. Solis, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept the guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Again, it's important that you stay in touch with Mr. Travis prior to that date so that you're prepared for that hearing. And before you leave today, I need you to go across the way to the probation department office. Okay. And they will give you a packet to fill out there. Mr. Ziegler, anything further on this file today?
No, Your Honor.
Mr. Travis?
Nothing further. Thank you.
Thank you. That's all for today.
Order cashier's check.
And then bring it back to the prosecutor's office. Yeah, do probation first.
All right, Mr. Travis. Matter we had was People versus Ross Smith.
Yes, Your Honor. Just a minute to grab Mr. Smith. I believe he's outside.
Mr. Schiff, we're running just about one file behind here. So I've got one sentencing to take care of, and then we'll proceed with Mr. Paichaki's case, okay?
That's fine, Your Honor.
Thank you. All right, Mr. Smith, if you come up to the podium here, please. On the record in People versus Smith, case number 2308. The record should reflect that Mr. Smith is present here in the courtroom today. If I could have counsel put your appearances on the record.
Brian Ziegler, on behalf of the people, Your Honor.
Kyle Travis on behalf of Mr. Smith.
Thank you.
That's okay. Your Honor, I do have two letters if we could give us before. One is for a medical appointment tomorrow. The other is from Mr. Smith's employer.
Mr. Ziegler, did you want to have an opportunity to review these, or did you already?
I reviewed them, Your Honor.
So, in Your Honor, I think we got an email relative to a change in the prior record variable scoring. It does not actually affect the guidelines.
Don't know that I got that, so can you tell me what changed?
Yes, it would be basically removing PRV 1 for 10 points in PRV 7 and shifting from 67 to 52 total PRV points.
Mr. Ziegler?
Your Honor, I did get that email from Ms. Wagner. It says that PRV 1 should go from 25 to 0. PRV 7 go from 0 to 10. Total PRVs would be 52 points. PRV level would not change.
All right. Thank you. The court will order, to the extent that that hasn't been changed in the SIR, that be changed.
Your Honor.
Yep.
I did send those. I believe maybe Jennifer was out of the office. That's probably why you didn't get that updated change. But I will make that in the after sentencing today. I'll make the correct changes.
Okay, thank you. Mr. Smith, have you had a chance to go through this report with Mr. Travis and talk to him about that?
Yes,
Okay. And aside from the scoring, Mr. Travis, are there any other additions, deletions, or corrections?
Just the letters we provided, I think it's indicated Mr. Smith is still dealing with some medical issues as he's got an appointment with a neurological doctor tomorrow. They're still going through a lot of those issues, but other than that, no.
All right, thank you. Are there any other challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Travis, or I'm sorry, Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring of the guidelines?
No, Your Honor.
Anything on behalf of the people for allocation?
Your Honor, I've had a chance to look through the report and the recommendations. Recommendations, I think the most concerning piece of this for me is that the defendant was on 7411 probation at the time he committed these offenses. To me, that suggests that he's not a good candidate for probation. He's also had other opportunities on probation sometime in his past. So I don't think we're at the point where probation is an appropriate sentence. The recommendation is for county jail, credit for 2 days served. A sentence of 12 months would be somewhere near the middle of guidelines, Your Honor. I think it would be an appropriate sentence given what the facts of this case are and given his prior record, taking into account the fact that he's just failed 7411 probation. The message needs to be sent that this is not the kind of conduct that we're going to tolerate, and that continued slip-ups will only increase the penalty. So for those reasons, Your Honor, I would ask the court to sentence Mr. Smith to 12 months in jail.
Thank you. Mr. Travis?
Your Honor, I disagree with that. I realize the guidelines are as such that likely jail is going to be a component of this, but I don't want to say it's benign, but the conduct here was unfortunate. He did fail his 7411 in Wexford. He was sentenced to some time for that. He didn't have an extreme amount or no particularly extreme conduct. He generally is a productive person. He's employed. His employer obviously wants to keep him around, even with his struggles and not being quite the employee that he was just a couple months ago. They're still very happy to have him there. He's still productive. He has family support. The significant others here, his daughter, I know, has tried to help both of them navigate a lot of this. They've struggled with a lot of his appointments and paperwork and kind of getting things together. I understand that the court may feel, and the guidelines indicate that jail is appropriate, but as reasonable as that can be, given unfortunately the very harsh guidelines that come with methamphetamine, given that it's on the deep rig, I realize that things are restricted. I can only, and I'm sure Your Honor's heard me say it enough times, say I disagree with the legislator. I think times have changed. I personally feel the reasons for that are from meth of a different era when it was more dangerous to the general community due to the way it was manufactured locally and causing apartment buildings to burn down and poisoning areas where children live. We don't have that anymore. It's all, unfortunately, I believe, generally coming from over the border now. So I would ask that the court to treat this more akin to a regular narcotics possession, taking into account that that the guidelines are fairly harsh from the legislator, and give him a more reasonable term of incarceration. Thank you.
All right, thank you. Mr. Smith, anything you wanted to say today?
I'm trying to get better. I read in there that it said I completed abuse counseling while I was on probation. But every day's been a struggle.
Okay, anything else that you wanted to say? All right, I did read through the report. I'm familiar with what happened in this particular case. There's also a lot of information in the report about your background and your circumstances. And so I take all of that into account, along with what the lawyers had to say. I did have a chance to read the letters here. that you submitted this morning. And, as you know, at some point your record starts to catch up with you, and that's at the point where you're at right now. You've been on probation, I think 4 or 5 times, you've had 4 or 5 jail sentences. And now you're looking at guidelines that call for up to almost 2 years in prison. So you're starting to get yourself in a position where any kind of issues are going to result in prison guidelines for you. I get, Mr. Travis, your argument, and lawyers sometimes make those kind of arguments in front of me. As a judge, I'm not in a position to just ignore the law because people think it shouldn't be the way it is, or I think it shouldn't be the way it is. My job is to enforce the law as it's written. And the methamphetamine laws provide for stiff punishments because it's a really dangerous and addictive substance. And unfortunately, it's a huge problem in this community and many communities. And maybe at some point the legislature will change the penalties for it, but at this point they haven't. And this isn't your first rodeo. You're going into this with your eyes open, and you know what the penalties are, because this isn't the first time.
I've been clean for, I think, 6 months.
And that's a good thing, and you're going to need to continue doing that, because like I said, if you don't get a hold of that, you're going to end up spending time in prison.
Yeah.
Because you're right up against it right now. The guidelines are 5 to 23. I think given the circumstances of this particular offense, in spite of your previous history, this isn't a particularly serious offense. So I think it calls for a sentence in the lower third of the guidelines rather than prison time. And so the court finds that an appropriate sentence is 8 months in the Kalkaska County Jail. You do have credit for 2 days served. The court is going to order that you pay a crime victim's assessment of $130, court costs of $325, attorney fees of $350, a DNA testing fee of $60, and a $68 state cost. You do have the ability to appeal this sentence. And the paperwork on Mr. Smith. Papers are going to explain to you what your appellate rights are, as well as how to request a court-appointed lawyer to help you with the appeal. And Mr. Travis, if you can have Mr. Smith acknowledge that you received those. And Mr. Travis, did you want these letters attached to the PSI?
If we could just have them back, I think.
Sure. You are remanded to the custody of the county at this time.
I give my old lady a
No, you need to go back.
I did.
People versus Taichaki, case number 234781 and 4782. Mr. Schimpf, are you able to hear me okay?
Yes, I can, Your Honor.
Okay, thank you. We have Mr. Schimpf here on behalf of the people. And we have Mr. Travis here on behalf of Mr. Taichaki, who's present in the courtroom today. This is the date and time set for sentencing. I know we have a challenge as to OB 16. But before we get to that, Mr. Taichaki, have you had a chance to go through the pre-sentence report? and talk
Yes, some, for the most part, yes.
Well, Mr. Travis, are there any additions, deletions?
No, I'm aware of, Your Honor.
All right. And the challenges to OB 16, I did have a chance to review your memorandum on that, Mr. Travis. Mr. Schimpf, I did receive your response as well. Any oral argument on that, Mr. Travis?
Your Honor, I guess having seen the AG's response, I would note that yes, that discussion does occur in the case, but the ultimate resolution, they don't end there with looking at the position of the defendant. I think the more important position is, as they address, as I quote, is there an actual loss? So my position would be that it shouldn't be scored, even though acknowledging it doesn't actually affect the guidelines also.
Thank you. Mr. Schimpf, did you want to make any oral argument for the record today as to OV 16?
I think the memorandum that was sent by Ms. Brenner states the position of the Attorney General.
All right, thank you. As council's aware, the court has to find that a particular variable is supported by a preponderance of the evidence, or a score for a particular variable is supported by a preponderance of the evidence. And looking at the record in this case, an OV 16 involves financial or property loss or damage to property. When it's $1,000 or less, it's scored at at 5 points, which is where it's scored at now. I did review that case as well as the statute governing OV 16. And I think it really does come down to a factual question. I think the statute for OV 16 requires that, or allows the court to score OV 16 in all cases except controlled substances cases. So, or for all felonies other than controlled substance felonies, which says to me that there are circumstances or facts under which you could score OV 16 for failure to pay child support, as we have in this case. So I don't think that it's just inapplicable generally to child support charges. So then it comes down to, do the facts here support that? And I think based on the argument made by the AG, I agree factually. There's no question that that the amounts were not paid. And so in my view, that results in a loss to both the receiving parent or payee parent and the child at issue. So the court finds, for those reasons, that OV 16 is properly scored at 5 points, and the court will deny the challenge. Were there any other challenges, Mr. Travis?
No, yeah.
Mr. Schimpf, did you have any other challenges to the guidelines?
No, Your Honor.
And Mr. Schimpf, did you have, on behalf of the people, any additions, deletions, or corrections to the report itself?
No, Your Honor.
Okay, anything on behalf of the people for allocution today?
No, just make it clear that the agreement is, if the defendant reduces his arrearage to $1,800, we would agree to reduce the charges to attempted failure to pay, which is a misdemeanor. If he pays off the entire arrearage, we would agree to reduce the charges to disorderly person misdemeanor under 751-67.
Okay, thank you, Mr. Travis.
Your Honor, that is our understanding, and I appreciate the Attorney General clarifying that. And that is, Mr. Pachaki and I have discussed that. He has been making his payments. He even has, essential to success in this, been making payments against his arrearage. He obviously would like to end up with a 93-day misdemeanor at the end. That is his goal, and he's going to continue to work towards that.
All right, thank you, Mr. Pachaki. Anything you wanted to say? No. All right, I've had a chance to review this file prior to today's hearing, as well as the PSI. I think this is an appropriate solution. Of course, the goal in all of these cases, Mr. Pachaki, is to get those arrearages paid down and get that money where it was supposed to be in the first place. And that's what this is designed to do. And so I expect that that's going to continue as it's been going here during the pendency of this case. So the court is going to place you on a delay of sentence for a period of 12 months. The court is going to adopt as all the conditions of that delay, all the terms and conditions listed in the report, with, of course, those requirements as indicated by Mr. Schimpf. The court is also required to impose a $68 state cost and a crime victim's assessment of $130, court costs of $325, attorney fees of $350. The court is also going to impose a $30 supervision fee during the period of the delay that can be paid at $30 per month. And that all relates to the child support portion of this case, which is docket 4781. As to docket 4782, Mr. Ziegler, did you have any allocution on behalf of the people or any changes, corrections, or otherwise to the
No additions, deletions, or corrections, Your Honor. We would support the recommendations contained in the PSI as to 4782.
Thank you. Mr. Travis, anything different or additional as to that file?
Nothing different, Your Honor. Thank you.
Mr. Pychaki, that's the controlled substance offense. Is there anything different or otherwise that you wanted to say as to that?
No, Your Honor.
Again, I think that recommendation is appropriate as well to fines and costs. So the court is going to order a crime victim's assessment of $75 and a state cost of $53. 5 days in the Kalkaska County Jail with credit for 5 days served. As to the delay of sentence, there are no appellate rights, but you do have the right to appeal the second sentence cost, as I indicated. Mr. Pychaki, we're going to provide you with some papers that explain what those appellate rights are, as well as how to request a court-appointed lawyer to help you with that appeal. Mr. Travis, if you could just have, or let me know once Mr. Pychaki is acknowledged receipt of those. Mr. Schimpf, is there anything else that you need to address on behalf of the people today?
No, Your Honor.
Mr. Ziegler, as to your part in the case, anything further?
Nothing further. Thank you, Your Honor.
Thank you. Ms. Wagner, do you want Mr. Pychaki to check in at the probation office before he leaves today?
Yes, please. Thank you.
Okay, so if you can just check in over there, Mr. All right, thank you. Good luck going forward.
Thank you.
And Mr. Schimpf, you're free to disconnect at this time.
Thank you very much, Your Honor.
People versus Nichols, case number 2348827. I could have counsel put your appearances on.
Ryan Ziegler on behalf of the people, Your Honor.
Kyle Travis on behalf of Mrs. Nichols.
And the record should reflect Ms. Nichols is present here in the courtroom today. I have this set for entry of a plea. Mr. Travis, how are we going to proceed?
Yeah, my understanding is this plea offer would be to plead to the third into the sobriety court with the regular terms that would entail, with successful completion allowing for the conviction to enter as a second. It is my understanding that she has been accepted. Mr. Ziegler can maybe speak more specifically to that, but I spoke with Ms. Nichols has been informed she's been accepted. Ms. Wagner followed up, and I believe everybody knows that. I don't have any paperwork to hand the court to prove that, though.
All right, Mr. Ziegler.
Fair statement of the offer, Your Honor. I can't confirm that the team voted. She was accepted into the program.
Okay, so Ms. Nichols, is this how you wanted to proceed?
Yes,
Can you raise your right hand, please? Right hand.
sorry.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Aye.
Thank you. Ms. Nichols, are you currently on any kind of probation or parole?
Yes,
Okay, and where is that out of?
out of Traverse City.
And are they aware that you're entering this plea today?
Yes,
So have they already imposed some type of penalty or told you what's going to happen with your probation there?
it's continuing as the same because this was prior to my sentencing for them.
Okay. And you understand that the maximum possible penalty that you could face for this charge, which is operating while intoxicated third offense, is up to a $5,000 fine and 5 years.
Correct.
With that in mind, what is your plea to that charge today?
I would like to continue with what I have been offered and enter sobriety court.
So you're gonna
Those
plead,
stipulations.
you're gonna plead guilty
Yes,
today. I'm gonna go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand that you have all those rights.
yes,
You understand that you're giving up and waiving all of those rights by pleading guilty.
yes,
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to do that, you'd have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. You understand that?
yes,
Has anyone threatened you with anything to get you to plead guilty?
no,
Has anyone promised you anything other than what we've said here in court today?
no,
Is it your own free choice to enter this plea?
yes,
Are you pleading guilty because you are guilty?
yes,
This happened on April 9th of 2023. Is that the correct date?
correct,
And on that date, had you been consuming some alcohol?
yes,
And after you consumed that alcohol, did you operate a vehicle on County Road 612 here in Kalkaska County?
correct,
And had you consumed enough alcohol prior to operating that vehicle that you were intoxicated while you were operating that?
I was, yes.
Did you have any blood or breath tests to determine the level of alcohol?
I had both, yes.
And do you know what the result was?
I did not see the result.
Was it above a 0.08?
I believe so. I didn't see the blood result, and I don't remember the breathalyzer. I didn't receive it in the mail.
0.17, Ron.
Okay, if that test showed that your level was a 0.17, do you have any reason to doubt the accuracy of that test?
I do not.
Had you previously been convicted of operating while impaired in 2022 in the district court here in Kalkaska?
I had, yes.
And also in March 7th of 2023, and is that the Traverse?
Yes, it is.
Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Travis?
Yes, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Travis?
No.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your
Mr. Travis?
Yes, Your Honor.
Ms. Nichols, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with Mr. Travis prior to that, as well as the sobriety court, so that you're complying with whatever they need you to do.
Okay,
And then before you leave the courthouse today, you just need to go over to the probation department. They're going to give you a packet to fill out.
okay.
Mr. Ziegler, anything further on this file today?
No, Your Honor.
Mr. Travis?
Nothing further. Thank you.
Thank you. That's all for today. Ms. Nichols. People versus McGuire, case number 234847. The record should reflect Mr. McGuire is present here in the courtroom today. If I could have counsel put your appearances on.
Ryan Ziegler, on behalf of the people, Your Honor.
Kyle Travis on behalf of Mr. McGuire.
And Mr. Travis, can you tell me how we're going to proceed with this file today?
Your Honor, we would ask for an adjournment. We did waive the preliminary exam in this matter. And one issue was Mr. McGuire's residence. It's my understanding he's going to be moving in with his mother, who is a resident of the county. Currently, he lives up in the Alden area. It actually indicates that he did change his address. But in light of that and some other things we've discussed with the prosecutor, it's my understanding they would refer him to sobriety court and see how, if he would be accepted. So we'd ask for, and maybe a little bit more time, because it does seem to sometimes take a minute. I think we had to adjourn Mrs. Nichols a couple times, so maybe 45 or 60 days, Your Honor. But that is ultimately what we're looking to pursue.
All right, Mr. Ziegler, do the people have any objection to that?
You have no objection to the adjournment.
Okay, so I'll set this for a plea hearing in 60 days. Mr. McGuire, it's important during that period of time, number one, that you stay in touch with Mr. Travis, your lawyer.
Yes,
And number two, to follow up with any requirements of the sobriety
Yes,
board for admission into that, okay?
Yes, sir.
Mr. Travis, anything further?
Nothing further, thank you.
That's all for today. Thank you.
Thank you, sir.
People versus Helzel, case number 234824.
Nothing in the lobby, Your Honor.
Nobody's in the lobby.
No.
Mr. Ziegler, do you have any information on that file at all?
I do, Your Honor. The attorney for that file, Mr. Mason, and I did submit a stipulation to adjourn to the court. That was on September 28th. I did not receive a signed stipulation from the court. I don't know whether Mr. Mason just assumed that it would be signed and did not appear. But in any event, Your Honor, we do not have the criminal responsibility exam back as of yet. And so we wouldn't be able to make any progress at this hearing anyway. So I leave it to the court's discretion how to proceed in terms of Ms. Helzel and Mr. Mason's failure to appear, but we did see the stipulation.
Okay, I'm gonna set it for a status conference in about 60 days. We're still waiting for that exam. I'd rather give it a little more time than less. So if you have any objection to that.
No, Your Honor.
Okay. All right, that's all for the criminal docket this morning. I'm gonna take a short recess and then we'll be back with our 11:15.